Employment law, we're looking at commercial arbitration, and we're going to look at arbitration in the realm of intellectual property as well. We'll start with an introduction. I'm Aditya Kamath. I head advisory. I'm a partner with BCP Associates. Like you all know, we're a labor and employment law firm. So I'm going to focus on mediation and conciliation in the realm of labor and employment. Um, if you'd like to introduce yourself.
Yeah, I'm Gopalakrishnan, and I'm not an employment lawyer, and I've made it very clear that I won't like to enter into that field. And I'm a commercial lawyer, and my thinking and my talk about this will be limited to the commercial aspects of MSME, then RERA, Consumer Protection Act, and then Commercial Codes Act and rules, and such kind of mediation and arbitration and conciliation act. Of course, that will come into it, and I'll be limiting it to that only, and it'll be just taking you through the aspects of that entire why in India now mediation has become a necessity, and why by what is the force of law for that mediation coming into effect, and all these aspects we'll be able to cover with that.
Thank you. Mr. Bhatnagar, if you could introduce yourself.
Hello, good afternoon, everyone. I hope I am audible.
Yes, you are.
First of all, thank you, LexTalk team, for organizing this wonderful event. Unfortunately, I could not travel. My name is NK Bhatnagar. I'm the founder and managing partner of NKB Legal. It's a small law firm. We are located in New Delhi, and we do a lot of IP work. So, in consonance with what has been discussed just now, I'll share my thoughts and views on the scope of mediation, largely mediation in IP matters. So let's start the session.
Thank you. Thank you so much. I'm just going to lay a little bit of a foundation. I remember yesterday during the introduction, there were a lot of certified mediators, arbitrators in the audience. So, begging your pardon right at the beginning, I'm going to tell you how much I know, very simply from a labor and employment standpoint. So, first, I think the problem that we have is we tend to confuse these three terms. We tend to use them interchangeably: mediation, conciliation, and arbitration. But especially in the labor realm, they do make a significant difference how you address them. Conciliation is a mandate, the law requires it. Conciliation involves what we call a positive intervention. We need a person to effectively provide solutions. On the other hand, mediation is more about allowing the parties to come to a consensus, allowing them to settle their disputes. And it is probably one of the least used tools, unfortunately, in industrial disputes, something that should be used much more. The reason I say that is compared to a civil or any other dispute that you take, where you typically have two parties who are at it and who have a dispute and who'd like to resolve. An industrial dispute has a third stakeholder which we don't often consider, and this third stakeholder is the country, the state, its people, the economy. Uh, Considering that an industrial dispute can lead to shutdown, it can lead to loss of productivity, it can lead to loss of income, not just for the employees and the employer, but for the state, which loses taxes, which loses production. If it is an essential service, it also loses that essential service. So, with these aspects, the cost of taking this to court, litigating, arriving at a solution, and finally implementing that solution is really high. It's not just litigation cost, but we're talking about a lot of lost revenue, possibly lost livelihood that ends up as the end result, which is why mediation and conciliation both become an important requirement. In other realms as well, and the co-panelists can feel free to uh, give their inputs as well. These solutions of alternate dispute resolution have been seen to be a more cost-effective and a more workable solution. But of them, the one I think that's least addressed, at least in the realm of industrial relations, is that of mediation. We don't have a statutory requirement anywhere in the world to mandate mediation. There are conciliation requirements in countries like India as a mandate, but this trend, I feel needs to take off from this point. If we can also get the input on commercial and IP related.
Yeah, I think, I'll start with uh, a story, in the sense, see, all of us have known about, Mahabharata, the great epic Mahabharata. It started, why? Because Lord Krishna went to mediate on behalf of the Pandavas with the Kauravas, and it failed. So as a result, what happened is the entire war, it cascaded into a war situation. So had that mediation been successful, I mean, hindsight, there are two ways of looking at it. We would have lost a great epic called Mahabharata, which gives us a lot of life lessons. Or the other thing is that, once upon a time, there lived two kingdoms, and, they mediated peacefully, and they settled, and they got their 5 villages, or, 5 land, and, it's settled. Very recently, I was reading a book, what's called as, maybe I may be wrong. It's written by a forest monk, in the sense, see, in Thailand there are forest monks, and he was a Westerner who was like, equal to Indian IAM. He was working in a multinational company, and he left everything and went there. The essence of the book is that never ever think that whatever I do and whatever knowledge I have is the ultimate thing, and therefore, I'm not wrong. So, mediation or conciliation or arbitration or alternate dispute resolution arises from that thought. If you have the feeling that, okay, I may be wrong, then you approach the problem with an open mind. Otherwise, if you do not have an open mind, and if you say that, what I say is correct, and there is absolutely nothing wrong in what I say, my stand is correct, then it becomes a non-est, because nothing can be, there cannot be any mediation. Mediation means, or mediation or arbitration or a conciliation means, has to be a little bit of flexibility in both parts. So as far as Indian scenario is concerned, let's come to the factual concern. Then 2018, the Commercial Codes Act was amended to include that if I file a suit, I file something in the commercial court, in a difference of opinion is there, or a suit for recovery or a breach or whatever it is necessary for me to first mediate. And if the mediation fails, then only it will be numbered as a suit and taken for hearing. So that is there in the latest Consumer Protection Act, which was passed in 2019 in India. Repealing the old act. There also mediation is a necessity. And if the real estate regulatory authority is concerned, also the mediation is a necessity. And if you look at the MSME, Section 18 of the MSME says that if I go and file an arbitration before the MSME, mediation is a must. But the fact of the matter is, I want to ask is that, is mediation effective? Is only am I following a procedure? Because when I file a suit, we think is that, mediation is definitely going to fail, and therefore, I have to pass through that stage to reach the court. So that is the attitude. That is why I started with the Mahabharata and the maybe I may be wrong situation. Because everybody is very, firm on their beliefs and says that there is nothing, just let us go to the mediation, let it be passed. And then even if there's a partition suit, civil suit is filed also, they have to go for mediation. And mediation centers are there in High Court, they're in any district court, and everywhere it is there. So it is a must. It is the same with the family court law, or, maybe industrial disputes. Industrial disputes, if I understand correctly, is that, when you give a notice for strike, it is necessary that there should be a mediation before you actually go into a strike. That is what I understand. And later, coming back, before I come back to the other issues of the pros and cons of mediation, I will ask.
So if we could get
on the IP.
a brief intro on IP and mediation as well from Mr. Bhatnagar, that will help.
Yes, in fact, I must say, mediation in IP matters has effectively been a very, very efficacious tool to expedite the IP disputes, and I have at least experienced this personally. See, generally, going by my experience, in intellectual property matters, the scope of arbitration is relatively lesser than as compared to the role of mediation. Biggest factor being in most of the IP cases, the disputes relate to infringements. And you are dealing with infringers. You are dealing with somebody who is infringing your brand, or you are probably defending somebody who has been accused of infringing some plaintiff's brand. Now, in those cases, since the parties are not related to each other beforehand, there is hardly any possibility of any arbitral agreement or arbitration arrangement being documented between the parties beforehand. So, what survives is only the scope of mediation. Now, having said that, of course, as Mr. Gopalakrishnan also just mentioned about the mandatory pre-litigation mediation, which has now been introduced in the commercial suits. In IP suits, of course, since there are real-time evidences involved, which are probably required to be captured in real essence in many cases, and ex-party reliefs are also involved, temporary injunctions. So, in many cases, we are able to get a waiver for the pre-litigation mediation. But definitely, once the suit is instituted and our injunction applications under 39(1) and 2 are allowed, we definitely go on the process of mediation, and the court, in fact, directs us to mediate, and the results have been really wonderful in some of the very difficult cases. Because normally a plaintiff is able to build a watertight case. As I said, most of these disputes relate to infringements. So I have personally seen not many matters going to the stage of full trial. And this, in fact, is a very, very efficacious remedy for filing a suit and then taking it to mediation. And in most of the cases, I have seen that the wrongdoers, the infringers, are more than willing to settle the suit because they probably know that their chances are very dim. So, in IP matters, the scope of mediation is really, really appreciable.
Thank you. Thank you so much, Ms. Bhatnagar. So with that preliminary intro, I think we've all raised some very important questions. So I think we should talk about some of those. And in my mind, one of the most important questions we raise is, as lawyers, are we in some way responsible for the failure of this mechanism of mediation? Because we tell our clients that why settle for less? Why is it that you should agree to terms that you don't believe are in your favor? Show of hands if you've ever said that to a client. The other party is proposing terms. Why should we agree to those terms? We can get better. No one? I'm the only dishonest or honest lawyer here. Okay, one more hand. Okay, so it's typical for us to advise our clients as to what is in their best interest. Does that take away what mediation can achieve?
No, I think, your question is pertinent. To a great extent, the failure of mediation is arising from the respective lawyers who are advising on that. And, it's not completely with the lawyers alone, because, the parties also have that feeling that, I want to get something, I want to get rid of that, I want to get an order and all those things, So that is also arising. And to add to that, if the client insists, you cannot say anything. So in my former avatar as the head of a law department of a bank, what I did was that, if some account goes as a non-performing account, and if somebody comes for settlement, I'm the first person to say that, we need to settle it, because as far as I'm concerned, I look at it in a different point of view, because money is my raw material as a bank is concerned. So that raw material has to come at the right time. So if I may go to the court, I may get interest at 16% or 10%, whatever it is, and with continuing interest. But the fact of the matter is that you will be very glad, you will be very happy at the age of 3 or 4 if you get a tricycle. But at the age of 17, if you get the same tricycle by court order, it is of no use. So that tricycle has to be given to Bangarwala, because so it cannot be used by you. So the result is that it depends, and people in India, especially in India, including the lawyers, all of us, including me, and we need to mold our mindset that things has to be settled. Whereas I understand is that US there are mediators. Here also certified mediators are there. And in another case, in the IP case, what my panelists can correct me is that mediation has certain limitations.
True, I
So
think
it is
that
only on a contract you can, if I'm
exactly.
giving it to you, but whereas you can't get a blanket order if somebody uses it. So
That led to
mediation
my next
is
question.
not
Is it also because we don't see mediation as conclusive? And we know that problems will probably arise in the future. Therefore, we want to nip that in the bud and say, hey, it doesn't matter what happens now. This is going to end up in court. Is that the reason why this goes in that direction? That's another thing. Can we take questions a little later once we've had some input from all three?
No, I know that he is one of the mediators, and he's
Yes.
for the mediator, and he gives a lot of lectures on mediation. And I think therefore he will have an umpteen number of questions, and he can
yes.
also give us a little
insight. Yes.
We will take your questions after this.
Yeah, we just hear Mr. Bhatnagar and then come back to you.
Sure, but I just would like to make an observation on what
Yeah.
Aditya was saying. You see, mediation and the lawyers, the process itself is yet to reach the people, the end users. So once the credibility of the mediation process is taken to the grassroots level, mediation as a process, however much we lawyers and judges, the courts promote it, will not take off. There's a long way ahead of it. I'll take.
No, I'll answer that in one question, because on this is on a lighter side, is that mediation will be successful in India if there is a agreement between the client and the advocate that even if you mediate and settle the matter, you will get the full fees. Then absolutely no problem.
Yes, Mr. Bhatnagar.
Yes, in fact, very interestingly, Mr. Gopalakrishnan pointed out. But, sir, these days, even the clients have become mature enough, and we are having these kind of agreements that even if you settle through mediation, your fee is assured. At least I am having. So, absolutely, this possibility cannot be negated. The lawyers, in fact, advocates play a very, very pivotal role in getting the disputes settled through ADR, be it through mediation, arbitration, of course, only when an arbitral agreement is there. Now, coming to the aspect of IP, see why in our forte or in our domain, this is one of the most efficacious mechanisms is that we don't know the parties. We don't have an agreement with them. These are all unknown people. And especially in larger suits, suppose we are operating a suit with a John Doe order. A John Doe order permits me to continue adding parties as many infringers. Let's say I'm working for the India's most prominent packaged drinking water brand, and almost everybody in the industry who is making drinking water is infringing. Every bottle you see is a green color bottle with a green color cap with starting in B, ending in I. So ultimately, a stage comes where I have to file a John Doe suit and continue adding defendants to the suit. So now, if a suit of mine has got 112 defendants, that suit will never come to end in my lifetime. So the best way to handle it is put these parties in mediation, tell them you have to suffer a judicial decree, and they almost agree to every aspect. So mediation in IP matters, especially in larger IP matters, has been the best policy so far in our experience. And in fact, the most of our mediations are before the Delhi High Court Mediation Center, where the mediators are very, very mature people. And there have been parties who have denied, but the percentage is very less. So the burden of leading trial, leading evidence into the suit gets trimmed down, gets tweaked by almost 80-90%. In IP matters, particularly, yes. I know I must say that it's difficult to imagine taking up an IP matter and taking it from start to finish without the help of mediation. So at least I would say that it's one of the best things to have in IP.
Thank you. I think we'll go now a little more into each one specific subject. So if I could go straight away into labor and employment, you would most of you would be aware, at least in the Indian jurisdiction, that we have the Industrial Disputes Act, which mandates a process of conciliation. There is an officer appointed by the state, and a dispute first sends up at his desk before it goes further. Uh, a lot of disputes get settled, especially when the unions are involved. Individual disputes can be a little more difficult to get through. This is a mandated process as it stands today. Its success rate is pretty good, but at some point in time a breaking point is reached. But keep in mind, this is not mediation, this is conciliation. So the role played by that conciliator becomes even more critical. And we do observe a certain, which I think every system has a certain a few flaws. And the flaw we see is a lot of bias can creep in, especially with the conciliators, depending on how emotionally charged the situation is. What are the parties in front of him? And typically, when it's an employer-employee kind of situation, we always know that the weight typically is on the size of numbers. So the employer population is very small while the employee population is large. And several times you have one party coming out of a conciliation being disgruntled with the entire process or the outcome, which again, precipitates this matter. But under various jurisdictions, I was looking at jurisdictions like the Middle East, for example, we have a lot of push here as well, with especially the free zones coming up with employee or workplace mediation and workplace conciliation, which is allowing employees to, whatever grievances they have, to ensure that they're settled even before it takes that next step. So I feel that globally, especially where your employment is governed only by a contract, it should more or less become a set norm that you put in these three steps. You put in mediation, you put in conciliation, you put in arbitration as the final step, to ensure that the entire ADR mechanism is leveraged fully. And I feel that both employers and employees will benefit greatly. This can come in through active legislation or through contract itself. But there's a lot of fear when you put these into employment contracts, because you're dealing with large numbers. An organization yesterday, I believe it was Landmark Group, said they have 55,000 employees. So what if I have 30,000 employees that suddenly want to mediate? Is that even viable or practical? So that's something also that we might need to think of. So in this space today, as it stands globally, that's the kind of footprint that we have. And I will come to what's coming, but before that,
No, I think you're right. But before I come into the plus and minuses of mediation, in an employment contract, if you put a mediation, what happens is, as an employer, it is, as an employee, I have all suspicions, because that I'm going to fight against an institution. It's like, 10 people interviewing me for one post, and then I'm sitting here, and, therefore, even if they take a right decision, I mean, at a later stage, but still, I'm always, suspicious of the matter that, whether it is correct, because
the bargaining power is not equal.
bargaining power is there. It is not the bargaining power which, long back, Microsoft, he had it, because, that was sheer luck, that is it. But that is what prevents an employment contract to be put in a mediation, because, we have, I have told a few HR cases. While there are also, if you start mediation process, maybe it is a transfer, or, somebody wants everything, everything is looked upon in a suspicious manner. And they say that, somebody has been given something, so why don't I get it, and everything. So this mediation process in a big way in an employment happens when the annual rating is process happens. At that process, two things happen, because this is all experience. If you give a fairly good rating, nothing happens. If you give a fairly bad rating, there are two cases. In many cases, it turns out into a allegation that the rating was given wrongly because of some other thing, and it has all the ingredients of a posh case. So that goes into that technicality also. Coming back, as far as the commercial things are concerned, mediation is a relatively simple process, and people are flexible, and there is absolutely no rules and regulations are laid down, and even much better than arbitration, because of the fact that there also the person sitting in arbitration lays down certain rules and certain timelines are there. Here, you can have a free talk, and you can have a settlement, and this settlement is something where unlike a judgment or an arbitral award, these settlements are like a consent decree where both parties talk to each other and they enter into this agreement. So it is a win-win situation for both. But the disadvantages is that all mediations does not end up in success. And though the law says, all these laws says that there is a mediation, what I have experienced is that I do not have the statistics, how many prior mediation before the suit or a RERA or a consumer case is taken up will end up in success, or what is the rate of success. There is no absolutely no statistics on that. But the fact of the matter is that when it happens, and it is only passing through that way, and I'm still determined that I want to go and get a judgment or a decree, and that is the process. So I think something more has to be added to give teeth to mediation. That is not that is not lacking, because in the acts also mediation is only a process. You go there, and then you're called once, you don't appear, and second time you appear, and third time he gives a report, nobody appeared, and that's the end of it. So some teeth has to be given, and unless otherwise, this only remains in paper, and mediation will be. And another area of mediation which can be done is in the insurance sector, because abroad, if two cars collide or some scratches are there, there are certified mediators who come, and here it is not so. So that also, I mean, we need to propagate the mediation process in a big way with sanctions. With sanctions and power, then it will take off as a successful.
Good. I think you raise a few points that I would like to respond to on the employment, but before that, let's get Mr. Bhatnagar in.
Another important aspect in pertaining to IP mediation, I would like to mention is about the international disputes. See, number of times we have seen that there are trademark disputes erupting between parties located in different countries. So even on those fronts, basically a cease and desist notice at times works as an instrument of initiation of mediation or inter-party dialogue. And because, see, nobody, howsoever big a concern may be, unless it is completely unavoidable, nobody likes to go and litigate in a foreign jurisdiction. An Indian company working for somebody in the UAE, suppose the subsisting agreement lapses, by virtue of which certain trademark is being used, and the infringer in UAE or vice versa continues to use the said mark, or continues to violate the intellectual property, clear the stock, or anything like that. Even in those cases, though UAE, I gave the example of UAE, it is a reciprocating territory now, but even despite that, the hassles of an international litigation can be largely curtailed. And in fact, in those cases where the parties are known to each other, have a subsisting agreement, then one fine day the subsisting agreement culminates, and then even after that cessation of the agreement, the IP violation continues. In those cases, of course, we can take recourse to arbitration, because in such cases the arbitral clauses are usually there. So basically, the scope becomes we can have the arbitration route also, and through mediation also we can resolve. And if nothing resolves, of course, an international litigation will be unavoidable. So overall, I see alternative dispute resolution as one of the biggest hand tools of expeditious and efficacious disposal of intellectual property disputes. That's my
Thank you, Mr. Bhatnagar. So again, I said we'll talk a little bit about what's coming, especially in the industrial relations space, and then go to the others. So you brought about an important point of unequal bargaining power and how that is, in a way, dissuasive for people to get into mediation. So with these labor codes coming in now, we see that unequal footing is somewhat set to change. While collective bargaining has been continued the way it is currently, it does place the employer and employee on more or less an equal footing. One of the ways it does that is it makes a GRC, or a grievance redressal committee, mandatory. And this grievance redressal committee is going to play the role of a mediator, more or less, because its functions, the way it operates, has been left completely open. So the company can choose how it will run the GRC. It has equal representatives of the employer and the employee, and any employee with a grievance can now go to the GRC. And it's a mandate, it's going to be a mandate once the codes come for every company over a certain size in India. So that's really going to push mediation one step further. The other thing that we have changing is that knowledge-based workers, especially in India, are increasing, soon to be on par with what we term as blue-collar workers. So with that change and with them already having a certain bargaining power, I think that's going to make a big difference to this realm. Over to you.
One question: when you're saying that the industrial law is coming out with the grievance redressal committee is concerned. So my question is that does that grievance redressal committee, what is the constitution of that committee? Because if it is just from the management people are there, then it makes I mean it
So
is
it's a
not
50-50 constitution, 50% employee representatives and 50% employer representatives.
Yeah.
So it was currently there under the Industrial Disputes Act, but it was optional if I had another grievance redressal mechanism. That provision has been scrapped. So it's mandatory, and the constitution is 50-50 from both sides.
Yeah, grievance redressal mechanism is good, but the credibility of that institution has to be built. Otherwise, it's again
Absolutely.
because my roots are come from a state where in the whole world communism is still surviving, and also coming from a family which was into business. See, the fact of the matter is that we have always seen that ultimately it ends up in hooliganism, and so that should not happen. So there should be something more, and the willpower of the government or the rulers, whoever it is, see, irrespective of the party, should be there. I'm saying about industrial disputes only, not in. It should be there that there should be a mediation, and that mediation, if at all they arrive at it, it has to be some kind of a finality that should be there, because after that it is no.
You raise a very good point. So even under the new codes, the GRC's decision cannot be challenged before a conciliator unless that decision to challenge is backed by a union.
Yes.
So they've given it some teeth. To your point,
Yeah.
I think we're running short of time. So if you can, any concluding
No,
remarks?
I'll just touch upon. I
Yes,
think,
we have both of you.
Yeah, on the arbitration, because arbitration has now become a big way in India, and arbitration is concerned. There are a lot of amendments have happened, and amendments have reduced the time period where it has to be done, and also fixed the fees. Schedule 4 fixes the fees of the arbitrator, but that doesn't mean. And India, what I have to sum up in one thing is that India still has not transformed into an institutional arbitration method, and still we prefer ad hoc arbitration. That has to be stopped, because wherever I have done international arbitration, it's all institutional arbitration. It is very simple, and time limit is there, so that achieves then arbitration law. Arbitration is picking up. I'm not saying it is not picking up, but with all these things, still this ad hoc arbitration where I mean, senior counsels or retired judges or some technical person, that has to be stopped. They have to be in a member of that institutional in the institutional arbitration, and the time limit should be there. Then that can be done. So this is what I want to say about it. And to conclude, I want to say is that alternate dispute redressal mechanism has to be encouraged, developed, and it has to be given more teeth. And then we will have a good situation where lots of the clogging of the courts cases in the I mean the matters in the courts can be reduced to it. It's because lok adalats, I find that it is very effective, because see, very recently I mean, traffic police could not recover a lot of money. They issued notices for traffic, but they had a lok adalat, and they were able to collect 52 crores of rupees. So I think it is effective, but the way you approach the problem is more important.
Absolutely. Point well taken. Mr. Bhatnagar, over to you for concluding
Yes,
remarks.
in fact, I would also conclude by completely supporting and the views of Mr. Gopalakrishnan, who just said. In fact, that's a very, very lucrative thing to do. Like we have a tier system in our courts based on the pecuniary jurisdiction, a matter of a certain value to the civil judge, then to the district judge, and then to the high court. So likewise, we can definitely, in fact, that's a very, very bright idea to propose. We should have, instead of picking and choosing anybody for arbitral tribunal, for composing an arbitral tribunal, it should be done actually from a pool of, depending upon or based upon the size of the matter which is to be referred to the arbitral tribunal. The panel of arbitrators or a sole arbitrator must be chosen from that central pool or a central registry. It may constitute some former judges also, former district judges also, former legal experts also, and may include some practicing advocates also. So that's a very, very lucrative idea. Perhaps the law commission in our country will probably consider it someday. But definitely all these three mechanisms, arbitration and mediation and conciliation, they have a very, very bright future. I know they will be very instrumental in times to come to decongest the courts, because nowadays the clients as well as the lawyers are becoming very, very circumspect of the pendency, and we have seen some very good arbitrations and mediations taking place. So I rest my words with these opinions, and I'm sure that this ADR mechanism is going to be a very efficacious mechanism in times to come.
Thank you, Mr. Bhatnagar. Do we have time for questions? No, we're not. Unfortunately, out of time, but you can meet us one-on-one for any questions that you may have.
We'll take it offline.
Yes. Thank you so much.
Thank you so much. Thank you.